This is the MonDak OilField Review with host Jason Spees.
My name is Jason Spees, and this is the MonDak OilField Review, heard on the Crude Life Media Network. On today's episode, we talk with Josh Swanson with Vogel Law Firm. Swanson gives an update on the ongoing battle with the state of North Dakota and several North Dakota mineral rights owners in a bizarre case that just doesn't seem to go away. In just a moment, part of our exclusive interview with Josh Swanson with Vogel Law Firm, right here on the MonDak OilField Review. It seems everywhere I go these days, someone is telling me about the success of Hatch coaching. Listen to what professional speaker Mark J. Lindquist has to say.
He is a person in this market and now in markets across the country with Hatch coaching that is revolutionizing the way people approach the business. He's reinventing the way people look at the people model. That's why he brings in hundreds of people from all over the country who are trying to figure out how to do what he's doing in their market.
For more information, call 701-212-1572 or visit coachingwithhatch.com. That's coachingwithhatch.com. Welcome back to the MonDak OilField Review. My name is Jason Spees. Up next, Josh Swanson with Vogel Law Firm.
What happened was this. Back when the legislative session met in 2017, there was Senate Bill 2134, which I know you've covered it extensively, and you and I have talked about it, and that was a bill that established or said, okay, here's what needs to be done to figure out what the ordinary high water mark line is with regards to the historic Missouri River. Now, what it says in that legislation, which was ultimately codified at Chapter 61-33.1 of the Century Code, was the Army Corps of Engineers line is the presumptive line. Now, the reason they set the Army Corps line as the presumptive line is because the Army Corps of Engineers was in the best position back in the 1950s to determine where the high water mark was in the 1950s. Now, there's a March 2016 decision by the Department of Interior that lays all this out in great deal, telling the state of North Dakota, you cannot go in there, state, and decide to change the high water mark of your own volition of the historic Missouri River and say it's something else other than what the United States Corps of Engineers said it was. Well, that's exactly what the Industrial Commission did in adopting this order. The statute said that the state had to hire some surveyors to figure out what the ordinary high water mark line was. What I said at the time during the legislative session was the same poison pill that the legislators were putting in the bill calling for another study has the same problems as the Bartlett and West study that led to the legislation in the first place. Now, I've seen the article in the Williston Herald where there's folks that supported the bill that came out and said, well, we had to do this for certainty because of the REAP decision in 2013. That's horse crap. There is nothing about the REAP decision that required the Industrial Commission to adopt the Lincoln Associates line or had anything to do with the legislation.
To listen to the full-length interview with Josh Swanson from Vogel Law Firm or to listen to other MonDak OilField reviews, visit thecrudelife.com. That's thecrudelife.com. The MonDak OilField Review is part of the Crude Life Media Network. Check us out on Facebook and Twitter. All of our social media links are available at thecrudelife.com. From the staff of the MonDak OilField Review, my name is Jason Spees, asking you to keep calm and frack on.